I have spent a lot of years carefully telling people that my son Finn has autism. And that's because of something called the People First movement. This is a school of thought that says our language should always put the person before their condition. So according to the People First movement, you would refer to my son Finn as a person with autism. When I started practicing, this was commonly accepted as the politically correct way of referring to people with disabilities. But there's been such an increase in my son's generation in self-advocacy that now there's another school of thought, and it's the polar opposite of the People First movement, and it's called the Identity First movement. Identity first language refers to a person in the context of their diagnosis. So Finn is autistic under that school of thought because autism is an important part of his identity. One of the QR codes in the resources section of your materials has a link to a great article that's called The Significance of Semantics. It's by Lydia Brown, who is autistic. Lydia says, it's impossible to affirm the value and worth of an autistic person without recognizing his or her identity as an autistic person. Referring to me as a person with autism or an individual with ASD demeans who I am because it denies who I am. So where do we land? I'm not the language police. As long as people's intentions are good, as a parent, I don't take offense at whatever language they use. No matter what language you prefer, though, there are certain things that you should never say. A great way to make my daughter really angry is to refer to her as my normal child. And if you do that, you will find yourself on the receiving end of a lecture about neurodiversity. So Molly is my neurotypical child and Finn is my neurodiverse child. Another thing I can tell you from firsthand experience is pity is never welcome. Do not say that somebody suffers from whatever their diagnosis is. No matter what a parent tells you about their child, do not reply that you're so sorry. And finally, if you're not sure how to refer to somebody, you can always ask. When you meet with a family for the first time, one of the most basic things you'll find out is how old are their children? And there are certain ages that are significant for a child that has special needs. And the first one is age 18, or in some states, if the age of majority is 21, it might be 21. This is the age when the law treats the child as a legal adult, which means they have the power to make decisions about things like where they're going to live and what kind of medical care they need. They can also decide to do all kinds of potentially dangerous things like get married and borrow money and buy a car. So this is the age when a lot of parents decide to pursue guardianship over their child. If the parents don't bring that up, you should, if the child is around this age. 18 is also an important age because this is when Social Security considers the child to be a household of one for benefits purposes. So that means that we stop paying attention to the parents' resources and we only pay attention to the child's resources. If the family has planned wisely and the child has less than $2,000 in non-exempt resources, then he will likely qualify for SSI. So it's important to review not only the family's assets, but also the child's assets. And in fact, that's often where I start when I meet with a new family. If you see more than $2,000 in the child's name, you need to help the family dispose of those assets or convert them into an exempt resource. If a child is on the Katie Beckett deeming waiver, it often goes away at age 18, which is going to be before the application for SSI has been approved. And this is a big deal if the family depends on those Katie Beckett funds to pay for something like really expensive prescription medication. Medicaid won't tell you this, but in many states, you can extend Katie Beckett for up to a year while you're in the process of getting SSI. And in Georgia, the way you do that is you apply for SSI, and then you give a copy of the application summary from Social Security to the Katie Beckett unit of Medicaid. That documentation will trigger an extension of the Katie Beckett waiver until SSI is awarded or until the child turns 19, whichever happens first. If the child has assets that will cause them to fail the means test and they're too large to put into an ABLE account, keep in mind that the child can also create his own D4A trust, also known as a first party special needs trust, at the age of 18, assuming that they're otherwise competent to create the trust. So if there are parents out there who can do it, this might not be necessary, but if there's nobody else alive to do it, this is something to note. One way that a child can move from SSI to SSDI is to base that move on a parent's work record. But that can't happen unless the child has a disability that began before the age of 22. So if the child is on SSI before age 22, then you have presumptive evidence that the disability occurred before that age. So if the child has turned 18 and the family hasn't begun the process yet of applying for SSI, you should encourage them to get that done before the child reaches age 22. The child can only have an ABLE account under the current rules if the disability occurred before age 26. If the disability occurred later, and you want to make sure that the child's assets can be parked somewhere if necessary, then you might want to encourage the family to create a D4A trust, even if there are no assets to put into it yet, as a safety net. It's possible that this age, 26, is going to change. There are whisperings about this age becoming age 46 for the purpose of being able to open an ABLE account. But at the moment, 26 is the magic age. So 26 is also the age when the child often loses coverage under a parent's private health insurance. Some parents have no idea that this is coming. So it's a good idea to have the child eligible for Medicaid before this point. If the child's insurance is coming from military coverage or a few other sources, this may not be a problem. But most of the time, at age 26, they are no longer eligible to be kept on a private medical insurance. If you're advising family members with an older person who is looking to shelter assets from the means test, keep in mind as well that you can't create or fund a D4A trust after the beneficiary turns 65. If that's a situation that you find yourself having to deal with, it might be possible to contribute assets to a pooled trust after that age. All special needs situations are not the same. So it's important to pay attention to the diagnosis because that's going to inform our plan for funding the trust. Life expectancy is something to consider. Are we planning for a child who has a typical life expectancy? Are we planning for a child who has already outlived his life expectancy, or are we somewhere in between? Planning for a child who needs 24/7 hands-on care that's going to be very expensive will be different than planning for a child who's physically healthy, who can live somewhat independently, maybe with support. There are also funding considerations. Do we want to divide the assets equally among all the children, or do we want to divide them based on the level of need? And that's going to be up to your clients, but it's something to raise as an issue and something to talk about. Also, how much free care can we expect when mom and dad are gone? Are there 4 perfectly healthy siblings who all live down the street and are desperately eager to take care of their special needs sibling forever? Is the special needs child an only child? That's going to influence how much money we need to take care of this child. Again, I can't overemphasize how important it is to talk to parents about getting their children on benefits. Sometimes they don't understand how much of a chunk of the cost of care could come from SSI and then later SSDI and Medicaid. So there's one diagnosis in particular that is such a challenge that I made a slide about it, and that is mental illness. These are some issues that are especially important when you're helping a family plan for a child with a mental illness diagnosis. If ever there was a time to steer people towards using a corporate trustee, this is it. For the sake of every Thanksgiving dinner that this family is ever going to have, please advise people to name a professional trustee if they're doing a trust for a child or an adult child who has a mental illness diagnosis. And the reason for that is the corporate trustee is not going to feel pressured when the beneficiary gets mad because they won't spend 80% of the trust assets in the first year. Of all the jobs that there are to fill here, managing the money is the easiest one to farm out to a professional. So there's a lot of information in your resources about psychiatric advance directives. Those are an important thing to talk to your families about if there's a mental illness issue in the family. These have been around since the 1990s, and a little over half the states have enacted instructional psychiatric advance directive statutes. They have 2 parts, and the first part is the advance instruction. That is detailed instructions about treatment preferences. It's where the principal can give consent for admission to a facility and consent for contact. The principal can list medications that they prefer or that they don't want, and they can express their wishes about treatment methods. They can also give instructions about practical things like the need to contact an employer because they won't be able to go to work for a while. And then the second part is the healthcare power of attorney, which names an agent to make decisions when the principal is incapacitated. In most states, the psychiatric advance directive has to be witnessed and notarized. It can be overridden if the principal is admitted involuntarily to a medical facility. Once the person's been deemed incapacitated or incapable of making decisions, the psychiatric advance directive is not revocable until the person regains capacity. And the psychiatric advance directive is different from a healthcare advance directive because the healthcare directive requires the principal to think about a future condition, but the psychiatric advance directive is often based on past treatment experiences. So these have varying levels of success. But researchers at Duke University have developed a facilitated psychiatric advance directive, and that seems to be much more successful than the do-it-yourself kind, or even one that's been created by an attorney. And it's an unstructured, open-ended interview. It takes about 90 minutes, and it's conducted by a trained facilitator. So this is done while the principal is still lucid and able to make rational decisions. The facilitator educates the principal about what the psychiatric advance directive is and how it works. And they talk about the kinds of information they want to include. They ask questions like, what are you like in a crisis? What would you like us to do for you if you are in crisis? They make sure that the principal names an agent to speak for them if they lose the capacity to make decisions themselves. And the facilitator Also, make sure that the psychiatric advance directive is distributed to the right people and filed in the proper places. So, for example, in their medical records. One thing to be careful about here is conflicts of interest. It's always important to remember who your client is. If you're an attorney, you can't represent mom and dad in a petition for guardianship if you have represented the child. So while you should be educated about psychiatric advance directives so that you can educate your clients about them, it might not be appropriate for you to prepare one or execute one. So there are a lot of QR codes in your resources about the mental health resources that I found, because there's so much out there about psychiatric advance directives. If you want to see what the law is like in your own state, I would recommend that you look at the QR code that's called the National Resource Center on Psychiatric Advance Directives. If you go there and click on state-by-state information, you can get information about statutes in your state, and in many cases, they'll have sample forms that you can use that are specific to your state. So as I mentioned, it's important to pay attention to the child's income and assets. If they have income from SSI or SSDI, check the amount. If it's less than $841, and if it's $561, that's one of those numbers that should cause you to pause, because that means that probably the child is getting a 1/3 reduction in their SSI because of something called in-kind support and maintenance. And in-kind support and maintenance is determined to be present whenever the child is getting food or shelter from any source other than SSI or an ABLE account. So you can save your families more than they will pay you for the consultation if you catch this and tell them how to fix it. So one way to fix it is, if the child lives with mom and dad, they can have the child sign a room and board agreement so that they're no longer giving them food and shelter, they're charging them for it. That should cause Social Security to give the child the full amount of SSI. If the child lives someplace else, like maybe a facility where we don't have any control over what the food and shelter costs are, and they exceed the SSI amount, which they probably will, then we can launder our food and shelter costs through an ABLE account. Also pay attention to income from earnings. Earned income can reduce or eliminate both SSI and SSDI, unlike unearned income, which only affects SSI. So even if this is the case, it's often worth it for the child to have a job. And almost all of the time, the parents that I talk to are happy to take a reduction in SSI if it means that their child has a better quality of life, they have friends, they feel good about themselves, and they have someplace to go where, they feel like they have a purpose in life. So it may be perfectly fine with the family that the child is getting a little reduction in SSI, as long as they have that ability to earn income. Income from child support is a super big deal. It's an example of unearned income. Even though the payments are probably being made to a parent, child support that's paid for a child who is on SSI counts as income to the child for SSI purposes. And the way that that will be treated is Social Security will disregard the first $20 of the payment each month, and all the rest of that payment will offset SSI dollar for dollar. The only way to fix this is to have the divorce settlement agreement direct payments to a D4A trust. You can't use an ABLE account. It won't work. So also go looking for surprise resources. Sometimes the family doesn't even think of these as resources. And one big one is a non-exempt trust. So ask if there are other trusts in the family that might benefit the child. Grandparents are big culprits here. Sometimes They'll have an RLT that names the grandchild, or there will be a pot trust out there with a health, education, maintenance, and support distribution standard. And the child will be one of the kids in the group of beneficiaries. If those things are funded, that's a problem. So you might need to move the funds into an ABLE account or a D4A trust, or potentially you might even need to do a judicial modification of that trust. If the trust is unfunded, then that's relatively easy to fix. You can just hopefully do an amendment and modify the plan in whatever way you need to. Also, the child's own retirement account is a non-exempt resource for SSI purposes, and we'll talk about this more later. So remember that you're not just planning for a special needs child here, you're planning for the whole family. So don't forget to ask about the other kids, if there are any. Age is an important thing to note here, because if the other kids are young, maybe we need to do some trust planning for them. And it might be something straightforward like a health, education, maintenance, and support trust, a HEMS trust built into the will. Conventional planning when you have young kids is to do a pot trust, which is all the money goes into this big pot and all the kids are beneficiaries until the youngest one reaches some particular age. That is not a good plan if you have a child with special needs, because we can't have that distribution standard applying to the child. So one way to do the planning might be to have a separate share for the special needs child that goes into a special needs trust, and then do a pot trust for the other kids. I don't really like that plan either. Typically, if there's a special needs child in the family, I recommend that people split the funds at death among all the kids instead of waiting until the youngest child reaches a certain age. Ask the parents about the typical kids' prospects for education and independence. We don't just care how old they are. We want to know what's going on with them. And I often see two extremes here. The one that I see the most often is all of the special needs siblings are the future president of the world. They are therapists, they're going to medical school, they are special education teachers, they are completely committed to and even happy to take care of their special needs sibling someday when mom and dad are no longer here. But sometimes you will find that there is a child on the other extreme. So make sure that you find out whether the non-special needs child has issues that would be a big deal in any other family. I met with a family years ago who came to me because they wanted to do planning for their child who had Down syndrome. So we did a third-party special needs trust, and it was all very straightforward, and it was classic special needs planning. And then I said, what's going on with your other child? She was living with mom and dad and raising her son who had Turner syndrome by herself. She had already had 2 heart surgeries and she had just been diagnosed with bipolar disorder. And mom and dad didn't think she needed a special needs trust or any trust, and they had never considered getting her on benefits. So my point is that sometimes you need to be a source of perspective. I always, at the very least, include a backup special needs trust in any documents that I draft for parents, and I give the trustee the discretion to fund that special needs trust instead of carrying out the other, whatever the other plan might be for the other kids. Also, find out what the relationship is between the other siblings and the special needs child. Maybe we have some great candidates here for future trustee or guardian. Sometimes parents expect the kids to step into their shoes and carry on when they're gone. Other times the parents want to have a little separation between all of those administrative jobs and the sibling relationship. So find out what the wish is for this next generation family dynamic. There are certain family assets that you should also look for the first time you meet with a family. And all of these assets will shape the way that you plan for the family. And the first one is firearms. In many states, it's illegal for an incapacitated person to possess a firearm. If there are firearms in the estate, there should be a plan for passing those along. So I always ask the client to do a specific bequest of the firearms to somebody other than the special needs child. There's information about these other points in your materials, so we'll move on to life insurance. I look at a lot of balance sheets and lists of assets, and I see a lot of term life insurance out there. If we're planning for a child who is going to need financial support for the rest of his life, term life insurance is not going to meet that need. Special needs families are not Clark Howard families. So if the family assets won't be enough to fund the special needs trust, and if the clients are young enough to get affordable permanent life insurance, that's a really good idea. Sometimes we're planning for a child who has a short life expectancy, and then this decision is a little bit harder, but it may still be a good idea to have a permanent life insurance policy in place. But in that case, you should have a plan B for that insurance. There are policies that you can get that have a long-term care rider. So if the parents need long-term care insurance at some point in the future, the policy can be used for that if the child predeceases them. And finally, pay attention to the beneficiary designations on any assets that have a beneficiary designation. Before the Secure Act was passed, it was a no-brainer to tell the parents to name the special needs trust as the beneficiary of life insurance. But now the best use of life insurance might be to equalize gifts to siblings if the parents decide to leave all of their traditional IRAs to the special needs trust. Each policy should only have one primary job. One policy can't provide for the surviving spouse and also go directly to the special needs trust. So sometimes you need more than one policy. I mentioned a few slides ago that assets that the child has in a retirement account will impact the child's ability to qualify for benefits. Inherited IRAs will also impact benefits. So for SSI purposes, no IRA is an exempt resource, whether it's the child's own account or an inherited IRA. If the child personally has more than $2,000 in retirement assets, they will fail the means test and they'll lose the ability to qualify for SSI until you do something about that. The income test is also a factor if the child is on SSI. Distributions from a retirement account are unearned income, and that will reduce or eliminate SSI. SSDI is less of a problem because it's not a means-tested benefit. So it doesn't matter that the IRA is a resource. And SSDI only reduces payments for earned income. Distributions from an IRA are unearned income, so they don't count against the child. But even if the child is on SSDI, we still care about retirement assets in the child's name, and that's because of Medicaid. So for Medicaid purposes, all IRAs are an exempt resource, including inherited IRAs, but distributions from the IRAs count as income. So later in life, if we want to get nursing home Medicaid and they start doing calculations based on what income the child has that's available to pay for nursing home care, this is going to reduce the amount of nursing home Medicaid that the child is going to be able to get. So the way that we fix this, if the child has a retirement account or if they've already inherited an IRA directly, is unfortunately damage control. So the child can cash that IRA in without paying a penalty, even if they haven't reached age 59 and a half. And that's because there's an exception for withdrawals made by a disabled person. The child will still have to pay income tax on the withdrawal if it's a traditional account. Once you turn the account into cash, you can put it into an ABLE account if the amount is small enough, or you can use a first-party special needs trust. Even if you're not a financial planner, even if you don't draft special needs trusts for a living, you still need to know why the Secure Act is a big deal. Craig Reeves did a great presentation this morning about inherited IRAs and the Secure Act. So if you missed it, I highly recommend that you look at his materials. Before we can really talk about the Secure Act, we have to do a little background about how IRAs are treated for income tax purposes. A traditional IRA gets favorable tax treatment at the front end. You can contribute to it with pre-tax dollars and it grows tax-free. But when you take it out, you have to pay income tax on all of it. So if you don't need the money in a traditional IRA, you're better off leaving the assets to grow tax-free and postponing those income taxes for as long as you can. But the IRS wants you to start paying taxes on that money. So you have to start making withdrawals from a traditional IRA at age 72. When you reach that required beginning date, the IRS will tell you how much you have to take out every year. That amount is called the required minimum distribution, or the RMD, and it's based on your life expectancy, the number of years that the IRS thinks you're going to live. So every year, the IRS will look at the value of your IRA and the number of years left in your life expectancy, and it will do the math and tell you the required minimum distribution that you have to withdraw that year. Until the Secure Act came along, people with a lot of money in traditional IRAs would delay making withdrawals for as long as they could. And if they named a younger person, like a child, as the beneficiary of the IRA, the new beneficiary could apply their own much longer life expectancy to that inherited IRA, so they could take much smaller required minimum distributions every year. If the IRA was big enough, a family could stretch it like this for generations. And then in January of 2020, along came the Secure Act, which dramatically changed the rules for how we have to take distributions from an inherited IRA. Under the new rules, anybody who inherits an IRA in 2020 or later has 10 years to withdraw all of the money unless they fall under one of 5 exceptions. Under the Secure Act, certain beneficiaries still get to follow the old rules for an inherited IRA. And the reason that we love the Secure Act so much in special needs land is because a disabled beneficiary or trust for that beneficiary can still stretch the IRA by taking distributions based on their own life expectancy. The proposed regulations that came out this February include a safe harbor that a beneficiary is disabled if they have been deemed so by the Social Security Administration. So if our beneficiary is on SSI, that beneficiary is presumptively disabled and they can stretch the IRA. If your clients have a significant amount of their wealth in retirement accounts, you can use those accounts now to do income tax planning. The special needs child is likely to have very little taxable income. They might even be below the poverty level. So shifting the income tax liability to that child is better than dividing a traditional IRA equally among all of the children. It's important to make sure that your clients leave the IRA to the special needs trust, not to the child, so it doesn't count as a resource. And there should be a provision in the special needs trust that lets the trustee make withdrawals from the IRA for income tax purposes, but keep the cash in an account that exists under the umbrella of the special needs trust. So sometimes families will want to equalize their distributions among all of the kids by leaving some or all of the traditional IRA assets to the special needs trust. But then if they have Roth IRAs, they'll leave those to the other kids. And this is also a situation where maybe we want to name the typical kids as the beneficiaries of life insurance if there's a lot of money in a traditional IRA. And we want to take advantage of the income tax planning opportunities by putting it all into a special needs trust. If your client has a military survivor benefit plan, this is another planning opportunity that you shouldn't miss. So under this plan, a person who's entitled to a military pension can continue those benefits after they die for a disabled adult child. There's a QR code in your resources that's labeled military pension assignment. And that will take you to the Department of Defense instructions for naming a disabled child as a successor beneficiary of a survivor benefit plan. And section 6 of those instructions will tell you the rules, which are also in this slide. It is possible to name the child personally as a benefit of this survivor benefit plan, but that's a terrible idea for the same reason that it's a terrible idea to name the child as the beneficiary of any other asset. Monthly income from the survivor benefit plan is considered unearned income to the child, and any payments that are still in the child's bank account in the next month will be considered a resource. So the better plan, and if you look at section 6.4.b of the Department of Defense instructions, it tells you how to do this, is to assign the survivor benefit plan to a first party special needs trust. We can't use a third party trust here because the right to receive the benefit belongs to the child. So it's a first party asset. Keep in mind that a first party trust is a parking space. It's just a place to store assets until we need them because there's a mandatory Medicaid payback at the child's death. So the first party trust isn't likely to have a whole ton of assets because that's the first place we're going to go to spend money if we need money before we touch anything in the third party trust. So it's probably going to be impossible to find a corporate trustee that's going to take on this first party trust. So if we have no younger family members or other people that are willing to serve as the trustee of the first party trust, then we may instead want to name a pooled trust as the beneficiary. A pooled trust is also useful if the family doesn't want to go to the expense of creating a private trust. So there are a few rules to note if you're going to work with survivor benefit plans. Once the owner of the survivor benefits has made the designation to a trust, it can't be undone. If the plan participant names the child rather than a trust to receive survivor benefits, you can fix it even after the plan participant has died. And the way that you would do that is the child's surviving parent or grandparent or guardian would irrevocably assign the D4A trust or a pooled trust to receive the payments. And if you are an attorney and you draft these trusts, from a drafting standpoint, there's no difference between drafting a first party special needs trust to receive survivor benefit plan funds and drafting it to hold anything else. The only thing that's a little bit different is that the drafting attorney will need to sign a statement certifying that the trust is a special needs trust created for the benefit of the disabled dependent child, and that it's in compliance with all of the federal and state laws that apply. So as long as the child is the beneficiary and not the owner of a 529 college savings plan, there's not a problem. Sometimes people freak out about this, and it's one of the few things that we don't need to freak out about. The plan assets don't belong to the child, and the child doesn't have an enforceable interest in receiving those assets because the owner is free at any time to name a new beneficiary or even to cash out the plan. So there's no effect on SSI. and there's no effect on Medicaid if the child is the beneficiary of a 529 college savings plan. But if the owner of the plan wants to get the funds out and they don't have a sibling that they can roll that money over to, they can roll it over to an ABLE account as long as they do it by January 1st of 2026. And then they can spend that money for any qualified disability expense. So it gives them more flexibility than if they leave it in the 529 college savings plan. So this will be a very few words about divorce. I did a whole talk on this last year, but I don't have another hour, so I'll just briefly tell you things that should be red flags. If you are working with clients who are divorced, you need to see their settlement agreement. And if the divorce settlement agreement requires any of these things, child support, life insurance, or medical expenses to be paid for an adult child who's on SSI and Medicaid, those benefits will likely be reduced or eliminated unless the agreement is drafted properly. And the way to do that, as I mentioned before, is the settlement agreement has to require the paying parent to make payments to a first party special needs trust. And if that's done properly, then the child support payments are not considered income to the child. Life insurance is even really a bigger deal than child support because it tends to be more money and it's a big chunk of money. But if the life insurance is required to be maintained for the support of a special needs child, you have to have it paid to a first party special needs trust. And if medical expenses have to be paid by one or both parents, you want to make sure that the settlement agreement has language in it that says that nobody is required to pay medical expenses that would otherwise be paid for by any local, state, or federal benefit. Like, of course, Medicaid is the big one here that we're worried about. So I did a slide on designing your practice because I assume that you chose this breakout session because you're in the early years of working in the special needs area. These are things that I wish I had known a long time ago. And the first one is be mindful. Now is the perfect time for you to think about what you want your practice to look like. Really think about it. The thing that you build doesn't have to look like anything that anybody else is doing. Don't sanitize yourself. If you want to have a purple accent wall in your conference room, please do it. Please hang pictures of your children in your waiting room. Please have cool books on your coffee table. Let your voice and your personality have lots of room. People like to know the professionals who take care of them. I have never had a single client tell me, we wanted to work with you because we love your academic credentials. But I have had lots of people tell me, we want to work with you because you're a special needs mom and we knew that you would get it. So it's okay to make your practice personal. Build your army. You know that saying, it takes a village to raise a child. When you're raising a special needs child, it doesn't take a village. It takes an army, and you need one because no matter how good you are at what you do, you can't do everything. Your families need people who can help them with all the things that are outside of your area of expertise. So you need to build a network of people that you trust to take care of your clients. And as you do that, you are going to become part of those people's network. And that's how you will create the web of relationships that will make you successful. Finally, and most important, remember self-care. I used to have a recurring dream that I was working my way through a massive list of really important things, and everything was on fire. There was no time to stop. There were all these things that needed to be done, and nobody could do them but me. And in this dream, I looked down and I saw this little baby at my feet. Not a fat, happy baby, a scrawny, sad little baby. And I thought, I don't have time for this. I don't want this baby. I don't know how to take care of this baby. This baby is not my problem. Somebody else needs to take care of this baby. And I kept having this dream. And finally, I did what I always do when I have a dream that won't go away and that I don't understand. I called my friend Shania, who is a little bit psychic, and I told her my dream. And she was like, oh my God, Kim, I know what this dream is about. That baby is you. You need to take care of yourself. So please take the time to be nice to yourself. People will forgive you if you take a vacation. I have one more slide for you. Years ago, I worked at an estate planning firm in Atlanta, and my boss was a brilliant man named Doug Duncan, and he was incredibly generous with his time. And he taught me a lot of things about tax, which I have mostly forgotten. But there is one thing that he used to say that has stuck with me for all these years. And here it is. People don't care how much you know until they know how much you care. So if you only remember one thing that I said today, I hope this is it. That's all I have. Thank you for listening.